Good morning. Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a warm hello to everyone in between. My name is Dan Balkaran, as you can see on the screen. And I am going to be your employment lawyer for the next half an hour, answering all questions about all things employment law. I am an associate at Samfiru Tumarkin LLP, Canada's leading employee side employment law firm. As always, just some housekeeping matters. If you'd like to contact us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, so we have some questions rolling in. Let's get to those now, and just please continue to send in your questions. Okay, so that's a unique name, so I'm not going to say it. Can an employer require you to work extra hours to make up for lost hours on holidays? I don't quite understand your question. Do you mean that you did not work a stat holiday and your employer is trying to get you to work extra hours that aren't paid for? No. But if your employer is asking you to work, or at least, no, the answer is no under employee protection legislation. But if you are being asked to work extra hours and paid overtime for it, certainly your employer can request that. You don't necessarily have to do it, although, again, as I stress every week, your relationship with your employer is one that you want it to be amicable across time, and so if you're denying your employer reasonable requests that are sort of reasonably connected to the four corners of what your job is, eventually your employer is not going to be too pleased with you. Now, that could lead to your eventual termination, or at least not a promotion, or just in your employer's bad book. So it's a relationship you want to manage over time, all of which, of course, is offset to a substantial degree by the fact that we're in a historically tight labor market right now, and so employees have more power right now than certainly they've had in a few decades. So I don't quite understand your question. Are you talking about stat holidays, or are you talking about something else? But I think we covered all the options, or all the bases. So thanks for your question. Richard asks, how long does it take from signing a retainer agreement with a firm until a letter is sent to the employer for a wrongful dismissal claim? I think that is unique to every single law firm and so I'm going to give you a non-answer. I apologize, Richard, but every single law firm and every single fact pattern. So if I have to write a particular demand letter for a wrongful dismissal matter for a new client, and it's incredibly complicated, that requires a lot of law to be put in it, there might be some delays, or if I'm in trial, there might be some delays. However, if it's a fairly straightforward matter, sometimes that can get out in a day. So it just depends. And if you're not content at the pace at which your lawyer is getting your communication out to your former employer, you can always follow up with your lawyer and ask for an update. Okay, thanks, Richard. Barbara asks, is making staff return full-time to the office after working remotely for months a fundamental change? Would it be classified as a constructive dismissal? Okay, so it's a good question. If you were an employee of that particular employer prior to the pandemic, prior to working remotely, I mean, I assume that what happened was you started working remotely due to the pandemic, and now they want you to come back to your office, there's nothing you can do about that. You don't. It's not a fundamental term of your employment that you work remotely. It was a change for a temporary change due to a specific reason, okay, which was the pandemic, a once in a 100-year event. And so, no, it's not going to be a constructive dismissal. Now, if you were hired specifically, like if you're hired during the pandemic specifically into a remote position, and your contract didn't contemplate that your employer could ask you to return to the office or come to the office after a period of time, that could be a constructive dismissal. You could say, well, no, it's depending on what the language is in your employment contract, if you have one. But you could say, no, I only agreed so I could work from home, which allows me flexibility for childcare and this, and this and that, and what have you, whatever your reasons for it are, and what your argument is. And then it could be in that situation, although, if you're pulling the trigger on a constructive dismissal and you're a 2-year employee, chances are that the severance amount that would be coming to you wouldn't be very large, so it might not be worth it anyway, unless you were a very high income earner, and even if you had 3 months of severance coming to you, but you were making $300,000 a year, that could still be a nice amount to get on the way out the door. So but no, I mean, employers have the right to ask you to return to the office. What a lot of them are doing is some sort of hybrid time where 2 days from home, 3 days in the office, that kind of thing. This was the issue in that the federal government workers strike that was happening recently that just got settled, where they wanted to work from home, and the government said no. On a case by case basis, yes, but not a blanket right in the collective bargaining agreement. And this is a very big issue for employers. A lot of employers, it's a balance, right? So on the one hand, if you can have 70% of your workforce work from home as an employer, that means that your office space footprint cost goes way down, which is a huge expense for employers. And so that's good. But on the other hand, there's this diminishing productivity that many employers feel they're experiencing because they don't have direct oversight or one-to-one oversight over employees who are in the office, and there are morale challenges. There are challenges sort of instilling culture when you're working working remotely. There are all kinds of challenges with it that employers may say, it's not worth it. We want to have you come to the office. So each employer is different, but no, to answer your question, it's not a fundamental change unless you were hired during the pandemic and there are specific circumstances that support that argument. JR, what is the best way to... Hold on a second. What is the best way... Oh, there we go. What is the best way to protect an employee's privacy rights, especially when using company equipment? Would a phishing email be grounds for potential cyberbullying? It seems like unwanted contact. I don't understand your question at all, JR. So you do walk around with certain privacy protections pursuant to the Privacy Act, I believe. There's a few other privacy pieces of legislation. I'm not overly familiar with them. It's not something that comes up more than tangentially in my practice. Phishing emails tend to be something that comes from outside of the workplace to induce you to click on something or log into something that allows a breach of your network. So I don't see how that would be grounds for any sort of cyberbullying moving from your employer, if that's what you're asking. So if you can clarify your question, Jared, that would be helpful. Tanya asks, does a doctor's note need to be updated whenever the employer requests it? The doctor's note needs to be refreshed pursuant to the timeline the doctor gives you. So I assume you're on medical leave, and your medical leave, quite often doctors will put a period of time on your medical leave. Sometimes they'll say indefinite, but usually not in the first note. And so they might say, okay, you're on medical leave for a month, and then we're going to reassess you in a month. If what you need to do is get a medical note before the end of that month, and then if your medical leave is extending, and give it to your employer. You don't want a situation where you're not working, you haven't returned to work, but there's no medical confirmation that you can't be at work, okay? Because then the employer can claim you abandoned your position. I mean, obviously, it's a little more complicated than that. They have to make an effort to find out what's going on with you. But I've certainly dealt with phone calls and clients where that happened, where the employer took advantage. Quite often there's an ongoing health situation, particularly if it's stress leave. The employer doesn't want you back, and so they will try to. I'm not saying in every situation, but in many situations, so the employer will do its best, or will sometimes take advantage of the situation and say, no, you abandoned your position. So that's when you need to refresh your doctor's note. Do you need to refresh your doctor's note just because the employer asks for it? No, if you're already covered by a previous doctor's note. But again, why you got to look at the context of the individual situation. Do you want to go back to that employer? Does it poison the well not to do the things that they're asking for you to do? I will say one thing about this. I just dealt with this matter on recently. If the employer, so a lot of times the employer will take a look at what the employee's on stress leave or something, and if the employer forces the employee on sort of a return to work program, the employee often just doesn't want to do that and then resigns. And so what I've seen employers do is they say, well, okay, you're on medical leave. We're happy to accommodate, when you're able to return to work, we're happy to accommodate your disability, even if it's on a gradual, return to work basis. We want more details about what's going on with you so we can come up with an accommodation plan. And you're not required to give those details to the employer. Simply a medical note from your doctor saying unable to work is good enough. There's nothing they can do at that point, the employer can do, without attracting substantial liability. But if your doctor does provide more information, that leaves an opening for the employer to then say, okay, well, we see you have X, Y, and Z problem. We can have you work, a few hours a day, every second day, with these other accommodations. So we want to do that. And then all of a sudden, if they've provided you a reasonable accommodation that works with the details your doctor has given you, you got to go back to work. And for a lot of employees, they just don't want to do that at that point in time, and they end up quitting. So, you've got to manage what you send back to your employer properly. Okay. You don't have to volunteer a ton of information, and you can rely on what your doctor says, but you can't have a situation where you are not at work and not covered by a doctor's note temporally. Okay. Hope that answers your question, Tanya. Art asks, his brother's employer told him they could no longer accommodate him. He worked from home when he was needed and was told it would have to be sick days. They terminated him for taking sick days. What are his rights? Well, if they fired him because he was unwell and had to take a sick day, then he has a human rights complaint in any jurisdiction that he's in, and he should talk to an employment lawyer immediately. So if he wants to talk to us, he could do so at employmentlawyer.ca. You can look us up. You can contact us at helpemploymentlawyer.ca or 1-855-821-5900. You can call us at that number. So I need more information. I don't understand the working from home wrinkle. Like, so for example, if they told him, I was just talking about this earlier in the broadcast here, but if they told him he's got to work in the office and he was working at home and he said no and he continued to work from home, that's not a sick day issue. That's an insubordination issue, and they can fire him and pay him zero for just cause, and they would win. So most likely, depends on what's going on with the medical stuff and the doctor's notes. Super complicated, Art. Your brother needs to talk to an employment lawyer right away. As I said, again, 1-855-821-5900. Okay, so a little more complication. Art's brother has diabetes and sometimes needs to stay home to manage symptoms or deal with his insulin pump. It'll depend on the specific facts of your case and what the need is and so forth. But there's something missing from what you said, because they're not your employer. If the employer fires you because you're taking a sick day, you right away you have a good case, at least in the Human Rights Tribunal, if not through the courts. But the working from home, like, is he just doing it himself, or is he advising his employer? Is he complying with policies of informing the employer? Like, there's going to be more information there, and you need to talk to an employment lawyer right away. Michael asks, 30 days in, broke my hip on the job, WSIB claim denied. What are my options? So I don't practice in this area, so occupational health and safety, and certainly I know very little about the occupational health and safety regime in Ontario, which is where I believe you are. Although I don't understand how, if you broke your hip on the job, that your claim would be denied. I think you need to talk to an occupational health and safety, a lawyer who specializes in that area. So it may be that we can refer you to someone here, in which case send us an email at send us an email at helpandemploymentlawyer.ca. We'll see if somebody can assist you here. But if not, we can refer you out to somebody else who specializes in the area. Okay, so this person, I don't know what their name is. I'm an recent immigrant from the Ukraine to Canada, and work in the shipping industry as a contractor for some companies in the US. Is it possible to incorporate for my work? Would I be able to hire my wife so she can handle the finance? Okay, this is not a question I can handle. This is outside of the scope of my expertise. This is something. So first of all, pardon me a second. So first of all, I mean, whether or not as an employee you can incorporate, no, I mean, generally speaking, and this is outside my scope of expertise, but as an employee, you can't incorporate. You have to be an owner of the business to some degree, be it a partnership or what have you. Sorry, you said you were a contractor. If you were a contractor, yes, you could. I mean, I deal with contractors all the time who incorporate, and if that's the payment arrangement you have, and you're not an employee, then certainly it's open to you to do that. And, I've talked to many contractors who have employees, so I don't know anything about this area, but I don't see why that would be a barrier. But it depends on your specific employment or contractor arrangement with your employer, which also touches on how you're taxed. Do you handle your tax yourself, or is on the wages you're paid, or does your employer withhold income taxes at source? There's some questions you have, but your questions here are really for your accountant, most likely, or at least that's the first point of entry. So I would do that. I would talk to your accountant first. Okay, another person with out a name, or at least a name I'm not going to identify. How many months severance is someone eligible for after 6 years of employment? It's a great question. So you are entitled to, if you're provincially regulated, you're entitled to a statutory severance floor that is roughly 1 week per year of service. However, depending on what's in your employment contract, you could get what's called common law severance, or there might be a specific amount of severance set out in your employment contract that is greater than the statutory minimums that I spoke about. So by default, automatically, if you're provincially regulated, you get 6 weeks of severance. If your contract if your contract permits it, we'll say, then you're entitled to common law severance. And common law severance is more. The general rule of thumb is 1 month of severance per year of service, but it varies based on your age, your length of service, what your position was, and how likely you are to get a new position. So, for example, I've never had a legal assistant as a client. The reason why I've never had a legal assistant as a client is if a legal assistant loses his or her job, they can find a new job. There's 200, at least in Vancouver, and I'm sure this is the case in Toronto. There's 200 jobs available right now for legal assistants in the city, and so there's no point in seeking, generally speaking, greater severance because they can find a job like that. And you'll see the same sort of, I shouldn't say there's no point, but this discount you get in law in terms of the amount awarded is substantial because there's so many other jobs available. You see the same thing with drivers, and historically speaking, anyway, waiters and waitresses, servers in restaurants. So generally speaking, 1 month per year of service, but it adjusts. If you're 25, that's going to go way down because you can get another job fairly quickly. But if you're 65, it goes up. If you're the vice president of sales, it goes up. But if you are, customer service clerk, goes down. So there's a lot of variability, but the starting point, 1 month per year of service, and then it moves around from there. It also depends on what jurisdiction you're in. So for example, on Ontario, you tend to get more generous notice periods. BC less so, Alberta even less so. Okay, question from Bernard. My employer has told me that I will need to travel for some for some work and be away from home for up to 6 months. That's tough. I don't think I can be away for this long because I have young children. Yeah, no, that makes sense. Can they fire me if I cannot accept the work? I work in construction, and I've heard that I'm not entitled to severance when fired. Okay, we'll tackle the second part first, the faster, the easier one. You work in construction. Okay, so there's a custom. I don't know about all the Employment Standards but in British Columbia, if you are a construction worker that works on construction sites, you don't get statutory severance. Okay, you're not entitled to it. However, it doesn't mean that you don't get common law severance, which is the greater severance, the 1 month per year of service I talked about. But if there's a customer usage, I think that's the term, customer or usage in your industry that you don't get severance, then you wouldn't. So the way I generally look at this is if you were hired into a job like a skipjack operator for a defined period of time, like you're gonna operate you're building a tower and you're gonna operate the elevator until the tower is finished, and it's a defined finite project. Yeah, that you might not have an entitlement to severance under the common law, although you might. But if you're a site superintendent and you work on 10 different sites and there's a ton of work for you and it was never contemplated they could lay you off like that, for a short, for running out of work, or your work isn't tied to a specific project. No, probably not. You're gonna get severance. Okay, so that's the second question, and it's the easier question. The first question about the travel. So the question is not can they fire you, because they can fire you for anything. The question is, can they fire you and not pay you severance? Right. So can they fire you for what's just cause and give you zero, because you can't go traveling for up to 6 months? Well, it depends what was contemplated at the time of your hiring and what was in your employment contract. So if this was never contemplated and it was never on your radar, then and they spring it on you out of the blue. No, that's that's not something you had contemplated. It's not something you agreed to, and no, they can't fire you. They can't pay you zero. They're going to have to give you some severance if they fire you. So that's a big change. I think what you need to do is be very. You also, by the way, would have most likely have, depending on the nature of what your requirements are for your young children, like driving daycare or child care yourself, or taking care of them. You might have a family status complaint under the human rights legislation in your jurisdiction. So, but what I would do is I would, by email, say to your employer, listen, I have these child care responsibilities. I can't travel that much, and certainly it's not something. I would just do it that way. I wouldn't go into that's not what we contemplated at the time I was hired or anything like that. That can come later. But I would just articulate very clearly why you can't, and the greater the sympathetic reasons for why you can't with respect to your children, such as it's not just I want to spend time around them, but I've got to look after them, or I have these childcare responsibilities, or I have this or that. The worst position your employer is in if they just try to impose this upon you, or if they fire you. Okay, but Bernard, you absolutely should talk to an employment lawyer and manage this thing through. Sounds like they're probably going to terminate you, and you want to make sure that you're hitting the right points as you go through this, and you seek the right compensation on the way out the door, because there's a lot going on there. So again, if you need to get a hold of us, employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Art is back. Art is the fellow whose brother got fired when he was working from home and got sick. They allowed him to work from home some days to accommodate his illness. New supervisor said that's not allowed going forward. He would have to take sick days instead. Then they fired him for taking too many sick days. Why didn't he just get a doctor's note and say he can't work in the office? He had to work from home. I don't understand that, but that's a very weird situation. I think if what you're telling me is accurate, your brother has a great human rights complaint, like a great one. So contact us right away, or it's again, help at employmentlawyer.ca, 1-855-821 $5,900. How can the public, this is a new question, how can the public policy exemption to at-will employment protect employees from being fired, and what are some reasons that violate that policy? I don't. Okay, so at-will employees, it's an American term. It doesn't exist in Canada. It just simply means that the employer can fire you and pay you zero. We don't have that here, except during the probation period or for just cause. So I wouldn't worry about that at all. If it says at-will employee in your contract, your termination clause in your contract is void, and you get the common law, which is the big severance, 1 month per year of service to a maximum of 24 months. Another question about from the same guy about public policy, same individual, public policy exception to at will employment. The public policy exception at will employment is that it's not allowed. We don't have it. It violates the Employment Standards Act, and I would assume, well, I wouldn't matter anyway if you're federally regulated. So I wouldn't worry about at will employment at all. And anytime I see at will employment in an employment contract, I know that my client is entitled to common law severance upon termination. So, I mean, if you have more specific concerns, please let me know. Tanya asks again, doctor has me off work only for the first hour. It's been a year. Employer asks for a new letter from the doctor. Does that need to be updated if nothing has changed? I don't understand your question, Tanya. Are you saying that you can't work for the first hour of a day on your shift? Let me tackle I don't know what your question is, but let me ask the second part of it. It's been a year, or answer the second part of it. It's been a year. Employer asked for a new letter from the doctor. Listen, if you haven't provided a doctor's note, I know what I said earlier, but if you haven't provided a doctor's note to your employer for a year, and your employer is accommodating you in some way, or you're not in the office, yeah, it's a reasonable thing for them to ask for an update. Just go to the doctor, get an update, and the doctor will say, yeah, this is still the situation. I will say, though, it's been a year, and if you're not working, after a period of time, if there's no possibility of you return, like, so 2 years pass, if there's no possibility of you returning to work, in the reasonable future, your employment could be frustrated, and you're effectively extinguished, and your right to severance is extinguished too. So you need to keep an eye on that. I don't, because I don't have enough information, Tanya, but maybe if you can clarify, though, we're almost done here. Pauline asks, are you still able to get EI based on hours from previous jobs if you're let go from a new position, or does the firing negate the opportunity for EI? My understanding of EI is fairly light. I will say my understanding is once you've banked up the applicable time, just because you lose one job and then go to a new job, are you able to still get based on the hours of previous jobs? I mean, I think the answer is yes. You have a banked amount of time. It's just if you draw down all the EI. So I can't remember how much EI is now. I think it's close to a year, 51 weeks or something like that. If you use all of your EI, and then you get a new job and then you lose your job, you might not have any EI to draw on until you bank it back up again. Is my understanding of how it works. But I'm fairly light on EI with respect to how the mechanics of it work. If you need, if you have specific questions that I haven't answered, feel free to give Service Canada a call. The only problem being with that is you're going to be on hold for a couple hours. But certainly you may want to give them a call about that. But that's my understanding of how EI works. Tanya clarified. So she's just missing the first hour of work in a given day due to her health issues. I think what I said earlier still holds. If you haven't provided a doctor's note to your employer in a year, go get a new one and just see what the doctor said. If the doctor just can continue to write a note saying this is the situation, then great, the employer is bound by the note. But it may be that your doctor gives you a different evaluation and says, you know what, I think you're fine to go back to work now and in the morning as well. But yes, I don't think it's unreasonable for your doctor to ask for an update, a medical update, after 1 year. Okay. You're welcome. This was about the at-will individual. And then And sorry, with the at will thing, if you've got it in your contract, it says they can fire you at will by paying you zero. That's great. That just means in the end, when they do, if they do ever terminate you without cause, then you're going to have a good claim, most likely to severance. So, and then Tanya again, sort of adding some more information. Only 1 hour due to change of job description. I don't know what that refers to, but I think we got that answered. I think we got everything answered. That was every single question. We did it. Thank you for all your great questions. So just a couple of housekeeping things. If you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. And I believe you can join us next week. There we go. Monday, May 29th with Chris Justice, 1:30 Eastern Time, answering all your questions, employment law. So please join us for that. It'll be great. And other than that, I hope you have a wonderful and safe weekend. I will see you here in this time slot in 2 weeks. And other than that, have a great weekend, everybody.